All right, so we've taken your advice and we've got ourselves a will. Let's say you have an ex-wife. Can that ex-wife contest that particular will?
Yes, she can. Under the relevant provision, but it's 57. Under Section 57 of the New South Wales Succession Act, a former spouse is eligible to challenge a will for under what's called the family provisions legislation. The family provisions legislation says that if a person does not leave sufficient money for one of their relatives, that relative can apply to the court to have the will amended and to be paid a certain increased amount out of the estate. Now there's a very strict set of eligible persons, and they include your current spouse, and that, by the way, is including de facto spouses. It includes children, it includes former spouses, and it includes grandchildren who have been at any time financially dependent on you, and it also includes anyone who's ever lived with you and been financially dependent on you. So the group is narrow. Oftentimes people think that their uncle or their brother or sister, etc., can challenge, and that's not right. Uncles and brothers and sisters, etc., are not within the group of people who are eligible. It's mainly a direct line, but you do need to be careful in the ex-wife situation, a former spouse. Now there is a way that you can avoid that if at the time of the property settlement, divorce and property settlement, the family court has no power in this area because these issues are dealt with under state law. The family court's jurisdiction is under federal law. So the family court has no jurisdiction in this area, but what you need to do at the time there's a property settlement, and while everybody's at least on the front foot as far as resolving everything is concerned, the parties can arrange for the Supreme Court of New South Wales to approve the property settlement and specifically order that neither party has any claim against the other's estate. That's a specific order that's required. It costs an extra $1,500 or so in terms of legal fees and the court fees, but it prevents your ex from having a claim against your estate.